Good morning, everyone. Welcome to today's hearing. Well, today we're going to continue hearing closing statements from a number of core participants. The first we're going to hear from is Mr. Lee Bennett on behalf of PSB UK. So, Mr. Bennett, when you're ready, please come up to the lectern. Yes, thank you.
Mr. Chairman, Mr. Stefan and Mr. Akbor, thank you for the opportunity to address you this morning. As you have indicated, I represent PSB, so my submissions address the topic of smoke control.
Yes.
And the smoke control system designed and subsequently commissioned by PSB as part of the refurbishment project. It will be recalled that this was a discrete topic held over from Phase 2, Module 3, and in respect of which important expert evidence was heard in Module 7. I will deal first with our general submissions on the evidence heard during Modules 3 and Module 7 about smoke control and the system. The balance of my submissions then address the night of the fire, and specifically the issue of whether or not the system caused or materially contributed to the injurious spread of smoke in the tower. So as to the Module 3 and Module 7 evidence, at the risk of stating the obvious, this is a subject matter that has proven complex and highly contentious during the course of the inquiry. Strong views seeking to criticise PSB have been expressed in 4 of the written closing statements you have received, namely those of BSR Teams 1 and 2, the Fire Brigades Union and Celotex, as well as in certain of the oral submissions that we all heard yesterday. PSB does not agree with the criticisms that are made. Indeed, PSB does not consider what has been said to accurately reflect where the evidence you have received in the course of this inquiry on this discrete topic now rests. In Module 3, the panel heard from 2 employees of PSB, Mr. Marnie, who led on the design at PSB, and Mr. Grenfell Partlow, who was the commissioning engineer. It is a matter for the panel to assess the witnesses coming before it and the evidence they give, and PSB does not seek to trespass on that function. However, we note that some opprobrium has been directed at Mr. Marnie by a small number of core participants. PSB certainly does not accept the characterisation of his evidence from certain quarters as being in any way capricious or anything other than honestly tendered. Both Mr. Marnie and Mr. Partlow have wanted nothing more than to assist the inquiry on this technical subject, even though at times, no doubt, the process was challenging. The inquiry has now also had the benefit of reams, frankly, of written expert opinion evidence from experts addressing some of the fields of expertise upon which the topic of smoke control touches, namely Dr. Lane, Mr. Lay, and Ms. Menzies. PSB made plain from the start that it disagreed with the evidence of Dr. Lane, and indeed that it considered many elements of it to be erroneous. Mr. Lay was initially instructed on behalf of PSB to mirror the work being undertaken by Dr. Lane and to produce an independent second opinion. In the event, Mr. Lay disagreed strongly with Dr. Lane, and although Mr. Lay was not wholly supportive of PSB's position, PSB considered that the inquiry may benefit from a second opinion, and so Mr. Lay's report was provided to the inquiry. Subsequently, counsel to the inquiry called Mr. Lay as an expert witness to the inquiry in relation to smoke control. For those seeking to criticise PSB, Mr. Lay is invariably described as, quote, PSB's expert, end quote, seemingly with a view to raising a question mark over his independence. If that was the intention, we would invite you to give that no credence. The panel has read Mr. Lay's report and his witness statement, and indeed you heard from him in 2 very careful days of evidence in Module 7. He made clear his duty to the inquiry and his clear understanding of it. It is simply wrong, we suggest, to paint Mr. Lay as a PSB apologist. Whatever view is ultimately made of his evidence, and that is a matter for the panel. That label is, we suggest, unwarranted and undeserved. It is a disservice to him and the work he has done with the sole purpose of assisting you and the inquiry. Something which both he and Dr. Lane described, if you remember, as an honour at the end of the days of their evidence. When considering the expert evidence in respect of smoke control, the panel must consider the totality of the evidence. That is not a trite point. A particular challenge in relation to this specific topic is to assess where the expert evidence actually rests after the oral evidence was given in Module 7. Unless that exercise is carefully undertaken by the panel, there is a risk that the written reports mislead and do not convey the final position of the evidence. The Module 7 oral evidence has had a significant bearing on much of the earlier written reports, in particular those of Dr. Lane. In our written submissions, and I appreciate they stretch to 60 pages or so, we have looked to point out where this is key in respect of the core issues as we see them. Most importantly, despite substantial evidence being presented to the inquiry criticising the system, including the making of assessments against what was the wrong standard, over the course of Modules 3 and Module 7, it has become apparent that there is in fact now no disagreement between the experts opining on smoke control that the system type, a mechanical extract-based system with natural inlet from the stair, was appropriate for Grenfell Tower. Dr. Lane's Module 7 report says that, quote, "There has been no criticism made by me of the form of mechanical smoke ventilation system chosen by PSB at the time," close quote. Dr. Lane confirmed in her Module 7 oral evidence that she did not criticise the type of smoke control system installed at Grenfell Tower, describing it as a, quote, "perfectly common system type in a suite of options available to designers," close quote. Even adding that they comprise over 1/3 of the designs that we, that being Arab, offer to people. It may, if I may observe, and perhaps to put it mildly, it is a shame that this was not made clear from the beginning. And frankly, a lot of work might have been avoided had that been the case. But panel, it's fair to underline that PSB is concerned that this has led to an overcomplication of, and a sense of transience to, the evidence adduced by Dr. Lane on the topic of smoke control, and as a result, in a simple word, confusion. For example, part of BSR Team 2's submission have relied upon Dr. Lane's earlier work to erroneously criticise performance and component specification and commissioning on the basis that they did not accord with that required of a Type B pressure differential system under BS EN 12101-6. Much of this confusion could have been avoided if, from the outset, it had been made clear that the system designed by PSB was a different system and a perfectly common system type. Significant consequences flow from the eventual agreement between all the experts that the type of system designed by PSB was appropriate. First, the choice of a mechanical extract-based system which used mechanical extract with natural inlet from the stair must necessarily mean that the system's core performance objective will be stair protection. This was adverted to by Dr. Lane in her oral evidence in Module 7, when she said, quote, "Yes, so when you pick that system, it can only protect the stair," close quote. Day 287, page 78, line 21. Second, the acceptance of this system type by the experts also reflects their now seemingly consistent position that the system's design objective to focus on protecting the stair was a reasonable and valid design decision. In relation to the lobbies, I know you've heard a lot about the lobbies, their travel distances and whether they required any special consideration. Mr. Lay said this in his report, quote, "I would not consider it unusual for designers and approvers to simply agree that the existing travel distances required no special consideration," close quote. That's paragraph 557 of the report. Mr. Lay's evidence was supported from a building control perspective by Ms. Menzies, who stated in her oral evidence during Module 3, I know that seems some time ago now, but if I might offer a simple couple of quotes. Quote, "Had I been looking at it, I wouldn't have raised the matter of extended travel distances being a criteria which they would now have to address under the new proposals." Day 169, page 32, lines 22 to 25. And, quote, "I personally would not have considered it being an extended travel distance in the context of Grenfell Tower," close quote. Day 169, page 33, lines 8 to 10. Dr. Lane's oral evidence during Module 7 was, with certain qualifications, and readily accept that, supportive on this point. In particular, Dr. Lane stated in relation to the decision to protect the stair only that, and I quote, "I understand it as a valid design choice," close quote. Day 287, page 76, lines 13 to 15. Moreover, that provided fire doors and dampers are maintained to the relevant standard, she would have been prepared to contemplate a smoke control system designed with the sole objective of staircase protection. Following the Module 7 oral evidence, PSB suggests that the inquiry, therefore, is left in the territory of determining whether the criticisms as to the quality of the system designed by PSB are made out or not. It seems to PSB that the premise for many of the criticisms alleged against it are now outdated, relying as they do on specific parts of reports prepared over many years now, which we respectfully suggest do not reflect the position now arrived at in the expert evidence. We offer 6 observations. The first of which, I promise I shall try not to repeat too many times, but I think you might be able to guess what this is. First, as agreed by every expert and material witness to the inquiry, the system was intended to address the effects of a fire on one floor and to deal with smoke from a single compartment fire. Based on the principle of compartmentation, that is the design assumption on which PSB was entitled to proceed. Consequently, the system was intended to operate on one floor only. The system could not have presented smoke from fires on multiple floors, impacting lobbies and the common stair. Second, there clearly was, contrary to what has been asserted, a coherent design basis for the smoke control system. The system was a perfectly common system type, the design elements of which are likewise common. It was a valid design choice and reasonable in all the circumstances. Third, it follows that the decision to protect the stairs was likewise valid and reasonable, as this system type focuses on protecting the stairs. Fourth, criticising these designs as, quote, surprisingly self-assured, end quote, or marked by arrogance, as some have suggested, is therefore, we suggest, unwarranted. Fifth, Mr. Lay and Ms. Menzies are at one in saying that they would not have criticised the travel distances in the lobbies of the tower, whether they are described ultimately as extended or not, as something that PSB would have to address. They required no special consideration. Therefore, criticism directed towards the system and PSB, and which focus on the conditions in the tower lobbies, at the assertion of some seemingly on all the floors, on the night of the fire are, we respectfully suggest, misdirected. Sixth, asserting that the system pressurised the lobbies, as is still being said, and going on to criticise performance, component specification, commissioning, etc., on the basis that they did not accord with that required of a completely different type of system, i.e. class type B pressure differential system under BS EN 12101-6, is simply incorrect. Panel, you have our Module 3 smoke control opening written submissions, in which we set out our position on the detail of compliance, design, component specification, testing and commissioning. You also have our detailed written submissions on the areas of contention after the evidence has been heard in Modules 3 and 7. Nothing that has been said by way of criticism causes us to resile from, nor warrants any change to the submissions that we have made in writing. The inquiry also has the benefit of detailed and careful submissions, we note, from our client, JS Wright, in relation to the system with which PSB agrees. PSB further refutes the suggestion that this part of the refurbishment project is to be elided with the rest of the refurbishment work undertaken at the tower in a narrative of systemic failure, incompetence or arrogance on its part or the part of its employees. This was a particularly challenging aspect of the works package, where a subcontractor was tasked late in the construction journey with finding a real-world smoke control solution within the fixed constraints presented to it. The panel is also urged to consider the discrete topic of smoke control in context and in perspective. Adopting the words, if I may, of BSR Team 1 in their written submission, the inquiry's investigation of the system has been extensive. And although for different reasons, we would agree that it now looks disproportionate. One meaning of that latter adjective is not deserving of its importance or influence. In the context of the Grenfell Tower fire, PSB sees a real danger that the topic of smoke control and the system is given an importance and influence that is neither deserved nor evidentially warranted. That would be a mistake. In some of the submissions you've received and heard, the evidence relating to the system has been strained beyond credibility. As an example, BSR Team 2 have asserted in their written submissions that as a consequence of the system aiming to protect the staircase, tenable conditions were not maintained in the tower lobbies and adjacent corridors, seemingly on all floors on the night of the fire. This is to misconstrue the causal relevance of a system which was required only and designed only to respond to a fire in a single flat on one floor, and where, on the night of the fire, all the occupants of the fire floor were able to pass through the fourth floor lobby to safety, and the LFB had the facilities to access flat 16 to fight the fire in that flat. It follows that placing the performance of the system in the correct context and in perspective is also particularly significant in respect of the issues of, first, the extent to which the system may or may not have contributed to internal smoke spread within the building by way of any breach of compartmentation. And second, the extent to which any such breach of compartmentation, as may be established in relation to the system, caused or materially contributed to the outcome of the fire. To that end, compartmentation and causative effect are the topics I now focus on for the remainder of my submissions. I first want to address the question of what approach the panel should take when considering this essential matter. We would suggest the following. Insofar as under Clause 1A of its terms of reference, the inquiry makes findings as to the immediate cause or causes of the fire and the means by which fire or smoke spread to the whole of the building, the panel will no doubt be alive to the fact that this is primarily an exploratory exercise which involves attempting to identify what happened as a matter of historical fact. In making its findings, we would encourage the panel to adopt a straightforward approach. Before finding that a particular event occurred, the panel should be satisfied on the evidence before it that it was more likely to have happened than not. Moreover, despite an understandable desire to fulfil the inquiry's terms of reference, the panel should not feel bound to make a finding of fact one way or the other where it is not supported by the evidence available to it. We suggest this is a sensible approach on first principles. This approach will provide a clear delineation between those areas where the inquiry has or has not been able to reach a conclusion on the balance of probabilities as to what occurred on the night of the fire or their causes. This is particularly so where the evidence available to the inquiry is complex and/or is contradictory. Further, given the potentially serious implications of any findings as to the cause or causes of death or injury on the night of the fire, PSB emphasises the need for such findings to be supported by evidence which is cogent and reliable. Fairness, if we may simply and humbly submit, requires nothing else. Despite certain alternative approaches which may be urged upon the panel, for example, Mr. Friedman, King's Counsel, yesterday referred to applying, quote, flexible standards of proof, close quote, the panel must caution against eliding criticism of a core participant's conduct with a finding that such conduct likely caused death or injury. Turning then to the evidence in relation to the night of the fire, compartmentation and causative effect. In short, PSB's position is as follows. First, on the evidence available, the panel may reasonably conclude that the system did not breach compartmentation and cause or materially contribute to internal smoke spread. Second, and in the alternative, if the panel considers that, on the evidence available, it cannot safely make a finding on the performance of the system in respect of compartmentation during the fire, that would be a conclusion also reasonably open to the panel. Third, apart from a limited assessment by Dr. Lane, which itself is caveated with a clear warning that no conclusions can be made without doubt, no expert suggests that the system breached compartmentation and caused or materially contributed to the spread of smoke. Indeed, in his detailed analysis, Mr. Lay takes entirely the contrary view. Fourth, no expert witness says that the system breached compartmentation and in so doing caused or materially contributed to the injurious spread of smoke. Fifth, no expert witness says that any act or omission on the part of PSB in relation to the system caused or materially contributed to the injurious spread of smoke. The case for alleging that the system breached compartmentation relates almost exclusively to Dr. Lane's storyboards, and they are contained in sections 12 and 13 of her Module 3 Smoke Control Report. Those purport to set out facts or hypotheses relating to the night of the fire. Dr. Lane, in the words of counsel to the inquiry, then provides a non-expert opinion as to what may have happened on the night of the fire in relation to the system and its effect on compartmentation. PSB has always been and remains deeply concerned about the way in which these matters have been investigated and presented in Dr. Lane's storyboards. Counsel to the inquiry was right in Module 7 to clarify and make clear the status of both Dr. Lane and Mr. Lay in relation to these matters, namely that they are not providing expert opinion evidence. It follows that there is in fact no expert evidence before the inquiry as to the factual questions of the operation of the system on the night of the fire and whether the system caused or materially contributed to the outcome of the fire. Moreover, and in any event, this is an area where Dr. Lane has also adverted to the difficulty in coming to any firm conclusions as a layperson. In her Module 7 oral evidence, Dr. Lane said, quote, "I understand. Well, actually, this whole thing about what actually happened on the night of the fire is quite dangerous territory to get into, because there's so many parameters that may or may not have impacted that system," close quote. Day 287, page 129, lines 17 to 21. Dr. Lane has also stated in her report that, quote, "I would like to re-emphasise the catastrophic conditions within Grenfell Tower and its impact on the evidence, which in my opinion make it impossible to opine with any certainty on one specific scenario," close quote. That's a paragraph 9.7.7. PSB agrees that in relation to the system, this is indeed dangerous territory for the inquiry and the panel to get into, especially in the absence of forensic fire engineering evidence. Whilst it might be understandable, given the terrible loss of life, why somebody in the position of Dr. Lane may look to assist the inquiry, the approach that has resulted and the evidence generated is, we respectfully submit, inherently unreliable. In plain terms, the various stories as articulated by Dr. Lane in her storyboards simply do not add up. You have the arguments in our written closing submission and also that of our client, J.S. Wright, but please, if you'll allow me just to condense it by dealing with 4 key elements of the allegations against the system on causation as alleged by Dr. Lane. The first topic is dampers. Before I get to the causation aspect, I need to first deal with some background. Not much, I promise. The inquiry has heard considerable evidence about the dampers selected by PSB for use in the system. This is one area where the guidance and standards documentation available at the time and reviewed in detail during the inquiry can reasonably be described as a mess. The certainty with which it is now alleged by some that a specific standard of damper was required for the system was far from clear at the time. The smoke control industry's understanding in respect of lobby dampers for use in mechanical extract smoke control systems was stated at paragraph 8.2.5 of the SCA Guide 2012, namely that, quote, "No formal product standard exists for the use of these products in this application," close quote. The SCA Guide went on to list 6 potentially applicable smoke control damper standards. As stated by Mr. Lay, it is a fact that the SCA Guide, which was formed from a consensus of industry opinion, with engagement with government, reached a practical view on damper standards. This was the context in which Mr. Marnie had to go about his choice of damper for the system, and he was reasonably entitled to rely on what the Smoke Control Association said. In the event Mr. Marnie specified the Gilbert's 54 series dampers, he knew they were not smoke control dampers. He confirmed in his oral evidence that he had conducted a search for smoke control dampers and for fire and smoke dampers and concluded that the Gilbert's 54 series dampers were the only product available on the market and suitable for the system at the time. No cogent evidence has actually been provided to show that Mr. Marnie was incorrect in this conclusion. This was despite counsel to the inquiry requesting on the 21st of May 2022, considerably after Mr. Marnie gave evidence in July 2021, that Dr. Lane perform a retrospective search of alternative dampers available on the market in June 2015, almost some 7 years before. This put Dr. Lane in a difficult position, and she was correctly reticent in her oral evidence in Module 7. Entirely appropriately, Dr. Lane makes no attempt to conclude on the matter. Turning then to causation, it's alleged that the dampers were capable of allowing and did in fact allow undue smoke spread between floors via the shafts. However, in her Module 7 oral evidence, Dr. Lane revealed that, quote, "I was asked to look at leakage to see if it was a concern on the night of the fire, and I was going to try and quantify the leakage, and in the end, I wasn't able to do that satisfactorily," close quote. Day 287, page 179, lines 13 to 16. It follows that there is no quantitative evidence before the inquiry as to the comparative real-world performance of the Gilbert's 54 series damper and either a SCA guide compliant damper or a smoke control damper in terms of cumulative smoke leakage, noting here that all dampers will leak to some extent. Further, in the absence of either a specific alternative lobby damper, which could have been recommended for use as part of the system, and in the absence of some form of standardized testing relevant to the system, which would compare the performance of the Gilbert's 54 series damper as sized and specified at Grenfell Tower against any proposed alternative, the inquiry is not in a position to make a quantitative determination as to the effect of the specification of the lobby dampers upon the performance of the system on the night of the fire. Put shortly, there is no testing evidence to show that the Gilbert's 54 series dampers in application at Grenfell Tower provided a lower level of performance than that required to meet the functional requirements, or that they allowed undue smoke leakage. Insofar as any determination can be made as to the likely performance of the Gilbert's 54 series dampers, the test evidence that is available does support the dampers having characteristics that would make them suitable for use in the system, as to which please refer to our written closing statement at paragraphs 150 to 158. The view is supported by Mr. Lay as expressed in his evidence to the inquiry. In any event, even if the inquiry were to find that the dampers could allow and did allow undue smoke spread between floors via the shafts, as I will come to later in addressing what actually happened on the night of the fire, it seems clear that the volume of smoke that could have been spread by this route was very small in the context of smoke spread by other overwhelming means. Second, we turn to the allegation that the system did not operate, and this is about the initial detection of smoke and activation of the system on level 4. There is a good deal of primary evidence to support that the system was likely activated on level 4 on the night of the fire, and this became the active floor for smoke control ventilation. This is dealt with in our written closing submissions, but briefly to summarise, there's the physical evidence such as the auto dialer, the presence of smoke deposits in the level 2 floor smoke extract fan set and the dampers. That's all supportive of the system having operated in smoke control mode. Evidence is also available from BSRs and firefighters of the noise indicating the activation of the system's fans and of the movement of smoke from the level 2 vent. Therefore, far from not operating as intended, as is alleged, the evidence suggests that in fact the system did so, at least when the conditions at the tower remained within those for which it was required to be designed. Third, the dampers at level 4, level 11 and level 18 and the alleged smoke spread between those dampers on the shafts. There's been a suggestion by Dr. Lane that there could have been a movement of smoke via the north shaft between level 4 and level 11, because after the fire, the level 11 dampers were found in the open position. Dr. Lane opines that the dampers at those levels were open simultaneously. This is noted by Dr. Lane to be a breach of compartmentation, an indication of failure of the system, and a route of smoke spread. This has been adopted by BSR Team 1 as fact and characterised as a malfunction of the system during the fire for which PSB is to blame. We disagree. It is very far from certain that the north shaft level 11 damper was open from the start of the fire. Dr. Lane confirmed that she formed the conclusion that it was likely that the level 11 north shaft dampers were open for the duration of the fire based on the BRE analysis of the dampers. However, Dr. Lane conceded in her Module 7 evidence that she was not an expert in soot deposition and was not a forensic fire engineer. So, quote, "I can't tell timing." I hope I made that very clear, that it's not possible for me to confirm a time anything happened, close quote, day 287, page 225, lines 1 to 4. Dr. Lane also added, in respect of the position of the level 11 and level 18 dampers, quote, "It can't be taken out of that context, and everywhere I have likely and options, because I don't find that it's possible, as myself, to say one thing definitely happened, and I hope I haven't given that impression at all, close quote. Day 287, page 227, lines 4 to 11. The panel may therefore reasonably conclude that it is not possible to know with any degree of certainty when the level 11 or level 18 dampers opened, for how long they were open, and what caused them to open. The panel can also reasonably find that there is no evidence to confirm that the level 4 dampers and the level 11 dampers were likely open at the same time. Fourth, the alleged failure of the level 2 extract fan set and the bypass damper, which is number 3. Now, Dr. Lane contends that the smoke control extract at level 2 likely failed on the night of the fire, resulting in a failure of the system to extract smoke from the south shaft. BSR Team 1 in their written submission alleged that as a result, quote, rising smoke filled the south shaft and could leak through the substandard dampers even when closed. This again was a breach of compartmentation, which worsened conditions in the building as a whole. We disagree. The BRE post-fire inspection found that the smoke extract fan set and the inlet and outlet dampers had a significant coating of what appeared to be smoke deposits. The inlet damper, that's damper 3, was closed, but the outlet damper was open. The BRE observed that, quote, this suggested that during part of the fire, the south shaft smoke extract was functioning, but at some point, either during or after the fire, it was shut down or failed. The BRE said that it is not possible to say how, when, or why the dampers came to be in that position. Dr. Lane agrees with Mr. Lay that one possible reason for the closed position of the damper was due to power removal after the fire. Notwithstanding, Dr. Lane goes on to prefer other possibilities, including her preferred narrative that at or about 0147, the level 2 extract fan had stopped operating on account of damper 3 closing. And it's this narrative that has been adopted by BSR Team 1 as fact. However, this is a dangerous surmise. How, when, and why the level 2 bypass damper 3 ended up in the closed position noticed by the BRE during the post-fire inspection cannot be answered with any degree of certainty. The evidence, including the evidence of Watch Manager Moore, does not support the proposition that extract likely failed in the early stages of the fire, nor does it support the proposition that the system was not extracting from level 2. In any event, Dr. Lane agrees that it's likely that the level 2 smoke extract fan turned on initially, and this, along with damper 3 being open, would have drawn smoke down to level 2 and out through the external louvre. This was in accordance with the design, installation, and the results of the commissioning. Moreover, insofar as Dr. Lane weds herself to a time of 0147 for the level 2 extract to have stopped operating, it should be noted that before that time, all lobbies except for floor 7 are said by Professor Purser to have already been smoke-filled. Leaving aside the analysis of Dr. Lane and stepping back, PSB is also bound to point out that there is already a cogent and reliable explanation as to what caused smoke to enter the tower and to cause it to spread. That is, the rapid and catastrophic breaches of compartmentation caused by the external wall fire and the critical significance of the flat 6 doors at each level. Professor Purser's conclusions are important in this regard. In the summary of his Module 7 report, Professor Purser opined that, quote, the main origin of the toxic smoke first filling the lobbies on each floor was smoke from the burning exterior cladding, insulation, and window surrounds materials penetrating via flat 6 on each floor. This source of smoke had a rapid, catastrophic impact on conditions in the lobbies, and it's described by Professor in detail and very clearly in his report. And as stated by Professor Purser, the main origin of smoke spread into the lobbies was via the external fire penetrating through the flat 6s on each floor. The overwhelming effect of the external fire and the critical importance of the flat 6 fire doors to conditions in the lobbies can be seen in the contrast between floors where the flat 6 doors did or did not prevent smoke leakage. Turning to causative effect relative to death or injury, as I said at the beginning when I set out my stall, we're not aware of any expert which suggests that the system was causally relevant to death or injury on the night of the fire. Moreover, as we've already seen when we've looked at the storyboard analysis and those 4 elements, there is considerable factual evidence tending to show that the system and its components were not causally relevant to death or injury on the night of the fire. It therefore follows that the panel may reasonably consider that there is no cogent and reliable factual connection between any act or omission on the part of PSB and the injurious spread of smoke on the night of the fire. I've seen the clock. May I just steal a couple of minutes to make some closing comments? I apologise.
Right.
So turning to my closing comments. On the night of the fire, the system was required to perform during an extraordinary event. A multi-storey fire characterised by rapid external fire spread, the complete failure of the external wall, and rapid re-entry of fire to multiple flats on multiple levels. As Professor Torero observed at the outset of the inquiry's work during Phase 1, and forgive me, I think this quote is important, quote, "Given the scale of the event and the number of lobbies that were simultaneously compromised by smoke ingress, a fully functioning, compliant system would have provided negligible benefits to egressing occupants. Thus, any discussion of its compliance or functionality is secondary in the context of the Grenfell Tower fire." Close quote. PSB agrees with that, and proper account of this central point should not be lost with regards to the system. It is important that blame for the disaster should be directed at those who truly bear substantial responsibility for what occurred at Grenfell Tower. And whilst remaining cognizant of the major tragedy in which so many people died, it is respectfully submitted that PSB does not fall into that category. The panel may thus consider that it is time to put the system in proper perspective and to avert the present risk that the topic of smoke control is given an importance and influence that is neither deserved nor evidentially warranted in the context of the terrible events and consequence of the Grenfell Tower fire. Finally, having closely followed the entirety of the inquiry proceedings, PSB is deeply conscious that, as matters stand, it does not agree with the bereaved survivors and residents on this discrete issue. This is not a position that any person, individual or corporate, could be comfortable with, bearing in mind the deeply moving evidence that has been heard about the lives lost and impacted by the Grenfell Tower fire during the inquiry. However, it is hoped that by engaging with the inquiry on this complex topic, and irrespective of the findings that may ultimately follow, PSB has at least done all it can to assist the inquiry and the panel in its work. Those are my submissions.
Thank you very much indeed. Thank you. The next statement is going to be made by Mr. Jonathan Laidlaw, King's Counsel, and I think he's going to make it remotely. And indeed, there is Mr. Laidlaw on our screens. Good morning, Mr. Laidlaw.
Good morning, sir.
Can I just check that you can see us and hear us clearly? We can see you, certainly.
I can see you and I can hear you clearly. Is my voice at an appropriate level, sir?
Yes, that's fine. And I think everything looks set if you'd like to go ahead and make your submissions.
Certainly. Can I thank you first for allowing me to make my submissions from the north of the country? And I sincerely hope that the technology will allow you to hear what I have to say without interruption. It's now almost 3 years since I last addressed you on Harley's behalf at the opening of Phase 2 of your inquiry, as you will recall. And then, as you know, funding difficulties have constrained the extent of the representation the company has had available to it. So I have not had the advantage of having been present over the months which have since passed. And I know you will therefore forgive me if my grasp of the detail does not reflect the extent of the learning and what the panel now knows of the events which led to this tragedy. That said, Harley's people, Mr. Bailey Senior in particular, have continued to pay close attention to these proceedings. He remains concerned about the company's position and has been, as will be clear to you from the written overarching closing submissions and the addendum closing submissions as they touch upon the further work done by Professor Bisbee. He has remained concerned and much troubled by that which has emerged most recently about testing. In making these submissions on Harley's behalf, I'm not, of course, going to be repeating the detail of the various written documents the panel has received, most recently from the company. I know the panel will have careful regard to that material. Instead, in the hope that this is helpful, I will complement our printed submissions with short summaries of the principal points Harley seeks to make in closing. I'll also address those parts of the closing arguments of the other CPs, which contain criticisms of Harley and the arguments framed to persuade the inquiry that Harley's responsibility for what went so terribly wrong extends further than the company was prepared to accept when their case was opened. And so there are 5 sections to my submissions. The first is the focus for these oral submissions, but the regard as I will submit it that should be had to balance and for fairness for Harley. The second is the testing of the ACM products by the BRE in 2001 and the subsequent inaction. The third is the practices of the three main manufacturers of the predominant materials in the cladding at Grenfell Tower, Arconic, Celotex and Kingspan, who each knew that dangerous materials were being used in the refurbishment project. 4 is the significance of the testing which has been carried out in the aftermath of the tragedy, which makes clear that the overwhelmingly dominant factor in the catastrophic spread of the fire was the use of these materials themselves, rather than any detail of the design or installation of the facade or the location of the cavity barriers. And finally, given the importance of the selection of the materials to be used at Grenfell, I'll finish with a brief examination and a reminder of exactly what Harley's role was within the refurbishment project and what responsibilities it did or did not have in relation to the selection of those materials. So part 1 is focus and fairness by way of shorthand. As others have in their written submissions, we respectfully adopt for our approach your own observations, sir, at the conclusion of the evidence, in which you acknowledge that many parties had admitted certain failings, but emphasise the importance of focusing in on those failures which materially contributed to the catastrophic fire at Grenfell Tower. And in light of the expert evidence you have heard, we submit with respect that the significance of, for example, the use of XPS infill panels, defects in some of the installation work of the facade, and the absence of cavity barriers around the window openings is now of far less importance than it might first appeared. And it's outweighed by the presence of the highly flammable rain screen cladding and unsuitable insulation, failures in the regulatory and the compliance regime, and a flawed fire safety classification system and the unethical practices of manufacturers. Next to fairness, Harley cannot and does not expect to be airbrushed out of the narrative of this disaster. In its work, there were shortcomings, there were failings, and there were omissions which have been acknowledged and which will no doubt form part of the inquiry's findings. The recommendations your panel will make will lead to great change for all, and the way Harley worked will have to change if the lessons, as they must be, are learned. But Harley are also entitled, as I'm sure you will afford them, to fairness, to have their part judged both by reference to the company as it was 10 years ago or so, its size and what it did and did not hold itself out to offer in terms of expertise or otherwise. Contemporaneous industry standards are of equal importance, particularly in terms of the reassurance a cladding contractor would take in terms of fire safety from stated classification and certification. Harley's position in this respect is no different from the many other cladding contractors, architects, designers, and consultants who have used the materials this inquiry is now primarily concerned with on many hundreds of high-rise buildings across the length and the breadth of the country. There is also the nature of this project, forgive me, and the importance of recognising that a variety of contractors and specialists were brought together to carry out, supervise, and then to check the various different elements of the refurbishment work. That is, of course, the norm in construction projects of this sort, but it will necessarily lead to delineation and demarcation in terms of areas of responsibility. That said, I am, as I begin these closing submissions, acutely conscious that it must sound desperately unattractive to the bereaved, the residents and the survivors of a disaster of the magnitude that befell the residents of the tower, for one contractor to seek, or to be seen seeking, to avoid responsibility by placing responsibility for fire safety elsewhere. And in certain respects, as you, sir, have already observed, responsibility will, of course, fall to be shared. And I quote, merry-go-round of buck passing has become something of a headline in the reporting of parts of these proceedings. It figures again in the closing submissions, and in certain respects, it may be true. But there are obvious dangers, as I know you, sir, will have recognised, with a forensic tool of this sort. There may be corporate CPs who are entitled, as the residents of Grenfell were plainly entitled to say, we relied on others. We did not have, and we did not claim to have, expertise in fire safety, but we knew that others amongst those responsible for this project had such skills, and we relied upon them to get things right and to ensure that we did not fall into error. And so addressing you in that vein on behalf of Harley, it is not to engage in buck passing, but it is intended to explain why these materials, now revealed as a result of the work of this inquiry to be so very dangerous, came into the hands of contractors such as Harley, and then were trusted and so widely used, not just by Harley, but by many, many other contracting firms working in this jurisdiction and indeed abroad. Finally, just this in terms of my introductory remarks. At the beginning of phase 2 of this inquiry in early 2020, Harley's written submissions spoke of the horror which Harley employees felt as they saw on their television screens the unfolding of that tragedy on the 14th and 15th of June 2017. As the evidence has emerged over the course of this second phase, that horror has been supplemented by frustration and indeed anger. Those reactions arising both from the results of the recent testing, but also the practices now exposed and laid bare of the key manufacturers who consciously and deliberately pushed dangerous products into the hands of others who both took on trust what they were told, but also had no realistic means of discovering the truth about those materials. Part 2, the BRS's testing in 2001 and the inaction which followed. Over the course of this inquiry, Harley has, like others following these proceedings, become increasingly aware of the dangerous properties of ACM. But even at the time of making written closing submissions at the conclusion of Module 3 last autumn, they could not have anticipated the evidence which was later to emerge as to the testing carried out by the BRE in 2001, which demonstrated to those who were aware of those tests over a decade before the installation of ACM at Grenfell Tower, just how dangerous this material was. The panel will remember during the 2001 testing, a system that incorporated ACM failing catastrophically, what the evidence of Dr. Sarah Colwell was. And again, you'll remember she was the principal consultant at the BRE. She described, and I quote, how she was shocked at the speed it took off. And when asked whether the outcome of that test could be described as an inferno, she replied, and again I quote, "It was a very large, very rapid growth, yes." Dr. Debbie Smith accepted that this was a, in her words, catastrophic escalation. Brian Martin, variously described as the building regulations expert, specializing in fire, or the ADB man, working for the BRE, somewhat reluctantly accepted that the spread of flames during this test was, and again I quote, clearly very rapid. Within government too, Anthony Bird, the senior fire safety professional within what was then the Department for Environment, Trade and the Regions, which had responsibility for reviewing the building regulations and accompanying approved documents, stated that he was surprised by the results of the test, describing the conflagration that resulted from this full-scale test of an ACM rain-screen facade system as a very fierce, fast fire. None of the other materials tested failed as quickly or as dramatically as the ACM. In short, at that stage, the danger to life posed by PE aluminium panels, if used in rain-screen cladding systems on high-rise buildings, was obvious to anyone who witnessed or knew the outcome of the testing. Given that, as described by Dr. Smith, the whole point of this testing program was to get to the point where we could ensure that the products that performed badly would never ever be able to pass the test. As she said, the inaction that followed and the failure to prevent ACM from becoming not just permissible, but widely accepted and used throughout the cladding industry is, as it has been described by various of the CPs, shocking. Dr. Colwell was clear. She, and again I borrow her words, couldn't see that ACM would be an appropriate product for use in that application, referring, as she was, to the use of ACM in the facade of a high-rise building. What remains entirely unexplained is how or why that view, those views, which were clearly the only appropriate response to the outcome of that test, did not lead to action being taken either by the BRE or the commissioning government department. Anthony Bird could not recall ever being told by anyone at BRE about the severity of the test outcome, and it does not appear from his evidence that he or anyone else in the government department responsible considered any intervention to stop the use of ACMs following this test, nor any steps even to ascertain how many high-rise buildings then featured ACM rain screen cladding. It will be for the inquiry, and it's certainly not for me, if it thinks it appropriate to categorise the nature of these particular failings. But the point from Harley's perspective is the obvious one, which the panel will have grasped for itself. They were entirely unaware of this testing or of its clear implication in terms of the use of ACM products in high-rise rain screen cladding applications. If those details had been made known to the industry at the time, it is inconceivable that ACM would have become as widely used as it did, or that Harley would have accepted the use of such materials at Grenfell Tower. That testing not only highlighted the inherent dangers of ACM as a material, it also demonstrated that the fire safety regime and the use of Class 0 certifications in particular were fundamentally flawed. And again, despite the dangers highlighted by that test, no action appears to have been taken to withdraw or even review Class 0 as a concept. That was despite the terms of the report produced by the BRE in September 2002, which concluded that in light of those tests, issues around Class 0 and diagram 40 in ADB, and again I quote, may require further consideration. That further consideration appears never to have taken place. Again, the significance of that issue to Harley's position will be perfectly clear to you all. As Jonathan Sukala said, a reasonably competent cladding contractor would rely on fire classification certificates. The inquiry has previously heard expert evidence from Dr. Lane that the BBA certification in respect of Rhinobond ACM, and the claims made within it that Rhinobond could be regarded as class 0 are factually incorrect and potentially misleading. Again, it is inconceivable that ACM would have achieved the dominance it has had the flaws in the very concept of class 0 been addressed by those who knew about those tests. Part 3, the practice of the manufacturers. Whilst the tests carried out in 2001 mark perhaps the beginning of a history of missed opportunities to prevent the materials used at Grenfell Tower from becoming as widespread as they have become, the years that followed were also, as the work of this inquiry has revealed, characterised by the deceitful strategies adopted by the manufacturers of those materials in order to push those materials onto the construction industry at large. And it's important at this point to weave into this chronology Harley's part in, or to put it more accurately, in fact, its lack of involvement in the selection of the materials for the Grenfell refurbishment. Arconic, as that company is now known, in 2012, through Deborah French, the UK sales manager, met, as you will recall, with representatives of Studio E and their contractors, Leadbitters, to discuss providing rain screen cladding panels for use on the refurbishment of Grenfell Tower. That meeting happened long before anyone at Harley had even heard of the Grenfell Tower project. And that meeting came after Arconic became aware that Rhinobond 55 PE in cassette form had achieved an F and an E in European classification tests carried out in June and October, of 2011. Those tests, those results were not referred to anywhere in the BBA certificate for Rhinobond, nor anywhere else in Arconic's project literature of the time. And Arconic knew perfectly well in 2012 that the performance of this product in cassette panels was worse than that represented in its BBA certificate. At this point, I pause briefly to respond to the observations made in the submissions for BSR Group 1 that BBA certificates cannot be treated as sacred cows or a guarantee of compliance. That submission, as a matter of respect, we would say cannot survive Mr. Sekula's evidence about the position at the time of the Grenfell Tower refurbishment. And he said this, and I quote, "I would expect them," that's reference to the reasonably competent cladding contractor, "to rely on the BBA certificate to a great extent, because the BBA is considered a reputable body and their certificates generally to be trusted." That is surely right, is it not? A contractor in Harley's position then was entitled to rely on the accuracy of such certificates. Neither, again, with respect, was it fair or appropriate for the same CP and their representatives to suggest Harley, and I quote, "displayed a contempt for the safety of those living at Grenfell," or to borrow from the submission made yesterday, it is more likely than not that Harley did know that ACMPE was not compliant. There is, I'm afraid, no evidence to support either of those propositions, and they should not have been advanced. This is also the moment to correct a misunderstanding that continues to exist about comments made by Daniel Arcotell-Jones in his email of the 27th of March of 2015. He observed, as the inquiry will remember, in that message that ACM will be, and to borrow his words, gone rather quickly in a fire. That became, in the submissions of Miss Barwise, the basis for an assertion that Harley knew ACM was highly combustible. But that point can only be made if one is prepared to ignore the evidence of the witness. What he meant, as he explained, was that aluminium would melt and fall off. That had been the experience of Harley, not just with ACM, but specifically with Rhinobond ACM during the fire at Taplow House. It was, I'm sorry to say, plainly wrong to suggest Harley knew anything of the sort, or of that which is now known and understood about the highly combustible nature of ACM. Returning then to Arconic, its knowledge of the performance of its rain screen cassettes was significant, because again, as has been observed by Mr. Sekula, as a manufacturer of rain screen panels, Arconic's knowledge and understanding of fire safety legislation and testing relevant to its products would be greater than that which could be expected of a reasonably competent cladding contractor such as Harley. Miss French's evidence that information about the subpar performance of Rhinobond 55 PE cassettes in fire performance tests would be given to customers who asked for it is, the panel may think, unconvincing. And Miss French herself was eventually driven to concede customers, and by extension Harley, would not know to ask about these more recent test results. Arconic cannot, we submit, simply abdicate all responsibility for the use of their products at Grenfell. They were perfectly aware that that product in cassette form was not suitable for Grenfell Tower or indeed any other high-rise building. Indeed, they knew that it was dangerous in any such application. Like any reasonably competent cladding subcontractor, and as Jonathan Sekula has pointed out, Harley were reliant to a very large extent on Arconic as a manufacturer of cladding products for advice as to the fire safety properties of that which they were supplying. No such advice was provided, and the absence of any warning or of any mention of the dire performance of the Renobond in European fire testing in 2011 is surely a matter of considerable significance. As for the other materials used at Grenfell, and those produced by Celotex and Kingspan, I can take the position shortly. This is dealt, as you will remember, in a little more detail at paragraphs 70 to 86 of our written 2021 submissions. When it comes to the manufacturers of the rigid panel insulation used at Grenfell, it is now clear that those individuals working at Celotex, from whom the inquiry has heard, knew and understood that FR 5000, the product suggested to be used as insulation, was not of limited combustibility and was not suitable for use above 18 metres. Yet every effort was made to drive RS 5000, which was essentially FR 5000 rebranded, for use in buildings above 18 metres. And the question that the inquiry will no doubt wish to consider and to address is whether Celotex were driven by the commercial desire to sell a product that could compete with the Kingspan product, which by that time was dominating the insulation market. Harley's consideration of Celotex's product literature was carefully examined during the course of the evidence, but no amount of reading that material would have revealed the truth that RS 5000 had only passed a BS 8414 test as a result of what has been described as dishonest and unethical over engineering. Again, the approach that Celotex took towards passing a BS 8414 test provides the essential context against which the eventual use of RS 5000 at Grenfell falls to be understood. It was the clear ambition of Celotex to ensure that that test could be used to market RS 5000 for use above 18 metres generally. The written submissions advanced on Celotex's behalf that Ray Bailey's evidence that Harley received assurances that RS 5000 was suitable for use above 18 metres is unsupported by documentary evidence is again to completely ignore context. Jonathan Room was meeting with Harley at exactly the same time that there was this internal drive to sell RS 5000 for use in buildings above 18 metres. Salesforce entries show that Celotex was pushing in relation to 2 Harley jobs, one of which must have been Grenfell. There's also Daniel Arcotell-Jones' evidence about the frequent visits made by Mr. Room and the unqualified assurances he and Harley were given about the suitability of RS 5000 above 18 metres. To that, one adds Ben Bailey's evidence of what he was told about the suitability of that product. The inference is, of course, for you, but we would submit that the irresistible inference to be drawn from the evidence is that Celotex representatives were anxious to convince the market that RS 5000 was a suitable product to be used above 18 metres generally, that they were in close contact with Harley regarding the Grenfell Tower project, that they knew what that project was about, and that, like almost all Harley projects, it involved the overcladding of a high-rise residential building. The tendency to dilute the limitations of the acceptable use of a product were also present within Kingspan and in respect of Cooltherm K15. Long before Celotex RS5000 came into being, product literature was being produced for Cooltherm K15, which, by suggesting that it was generally acceptable for use above 18 metres, was also thoroughly misleading. Critical information was omitted from the BBA certificate issued for K15 in 2008. That test was based on an old formulation of the product, and Kingspan had not declared the results of the more recent test in 2007, when the newer formulation had failed. As a result of this discreditable strategy, Cooltherm became dominant and widespread in the cladding industry by the time of the Grenfell Tower refurbishment. What was not known then at the time of that project, and could not have been known by any reasonably competent cladding subcontractor, was the extent of the dishonest methods that were employed by Kingspan to achieve that market dominance. Part 4, the testing of the cladding materials after the fire. I turn then to the post-tragedy testing, the fourth part of these submissions. What has become clear as a result of the testing commissioned by the Department for Communities and Local Government after the fire at Grenfell is that even when installed in perfect laboratory conditions, complete with correctly designed and installed cavity barriers, the combination of materials used at Grenfell Tower propagated the rapid spread of fire. That testing, like the tests carried out on ACM in 2001, saw fire spread so rapidly that the test had to be terminated a little under after 9 minutes, with flames reaching several metres above the top of the testing rig. Harley, as the panel will recall, has long maintained that this demonstrates the importance of the materials themselves and the relative insignificance, certainly in causative terms, of the design detailing and installation defects in understanding the events of June 2017. That point has now been underlined and Harley's stance vindicated by the experiments carried out by the inquiry's own expert, Professor Bisbee. Professor Bisbee's experiments, we suggest, conclusively demonstrate that the predominant cause of the spread and the intensity of the fire was the presence of ACM. Professor Bisbee has also made plain that this characteristic is not confined to Renobon 55 PE that was actually used at Grenfell Tower. In his view, and I quote, "All ACM PE products present extreme fire hazards. There are few construction products intended for any use on the outside of a building that I've ever seen burn with such intensity. Every time we ran an experiment that escalated to full involvement of the ACM, I was surprised and alarmed." But Professor Bisbee's experiments have also shone new light on the role played by RS5000 and the K15. Whilst there has quite properly been careful scrutiny of the selection of RS5000 and the extent to which the combustibility of that material and the K15 that was substituted for it, Professor Bisbee's experiments conclusively demonstrate that it was the insulating properties of those materials rather than their combustibility that contributed so significantly to the rapid spread of fire at Grenfell Tower. It was that insulating property, when combined with the behaviour of the polyethylene cord Renobond, that gave rise to the catastrophic spread of fire that was wholly absent from the fire at Taplow House on the Chalcots estate. That was an event as the panel will recall, which Harley had investigated and from which the lesson to be learned appeared to be that Reynobond would not contribute to the spread of flames. The clear implication of Professor Bisbee's experiments is plain. It was those three key materials, the Reynobond cassettes, the RS5000 and the K15 insulation, which were the predominant determinants of the spread of fire at Grenfell Tower. And what is of obvious importance to Harley is this. The Reynobond had been included in the MBS specification drafted by the architects, Studio E, it having been introduced to them in discussions with Deborah French of Arconic long before Harley's involvement, a point I accept I've now made twice. The RS5000, or its near equivalent, FR5000, again, was also specified in Studio E's NBS specification, it having appeared in documents produced by Max Fordham long before Harley's involvement. The K15, which by then had become so dominant in the cladding industry, was suggested as a suitable substitution for RS5000 by SIG. Whilst Harley has accepted that cavity barriers should have been placed around window openings, this was what was required by approved document B, these further experiments reinforced the views expressed not only by Professor Bisbee, but also by Professor Torero and Dr. Lane throughout this inquiry, that in a situation where there is a rapid flame spread and the deformation of the ACM panels, the presence or otherwise of cavity barriers will have little impact. It is these materials and not the detailing or installation of the building facade or the placement of cavity barriers within that facade which were the driving force behind the fire at Grenfell. And in our respectful submissions, your conclusions should reflect that. Part 5 is the correct description of Harley's role and the proper limits to be placed upon it. Next then to the role played by Harley in the refurbishment, because there remains a danger of that role being misunderstood, and at times the panel have seen in some of the submissions of other CPs of that role being exaggerated and thus misrepresented. It is therefore important that I take this final opportunity to return to this issue of precisely what Harley's roles and responsibilities were and were not. An example of the misunderstanding of Harley's role can be found in Ryden's written closing submissions at the conclusion of Module 3, where Harley are described as the specialist cladding designer. In the written submissions of BSR Group 1, it is asserted that Harley held themselves out as specialists in facade design. Not only do these descriptions not appear anywhere in the letter of intent, in which Harley was identified as the envelope package subcontractor, they also allied the crucial but generally overlooked distinction drawn by Jonathan Sukala between a specialist facade engineer or specialist facade consultant on the one hand and a cladding contractor on the other. At this point, I should say just something about the evidence provided by Mr. Sukala, because you know from the written submission that Harley has made previously that not everything that was said by him is accepted by the company we represent. The panel will remember that the process of identifying a cladding expert who not only had sufficient expertise, but who was wholly independent of any of the core participants, was an extremely difficult exercise and one that was drawn out. And we maintain that there are, regrettably, some important but inevitable limitations on the expertise of Mr. Sukala, which must operate to temper the veracity of some of the views that he expressed or the weight to be attached to them. Mr. Sukala himself has never worked in the role of a cladding contractor. He is, by his own account, a cladding or facade consultant, a role which necessarily involves more in-depth specialist and technical knowledge than a cladding contractor like Harley is likely to have. He cited only 2 examples of projects he has worked on involving the overcladding of high-rise buildings like Grenfell, and he appears to have had little or no experience of working on projects that required even the consideration of ACM products. And as such, there is a danger of placing undue weight on his opinion when it comes to considering the use of ACM products now, particularly in the wake of this tragedy, which should have been guarded against. Furthermore, as Mr. Sukala was frank enough to accept, his views on what are accepted industry practice at the time are necessarily impressionistic, An ability to speak authoritatively or confidently on contemporary practice amongst cladding contractors, such an important feature of Harley's case, is, as the panel will no doubt understand, of real concern to the company. That said, let me return to the substance of my submissions. Harley was and remains a cladding subcontractor, not a specialist facade consultant. And its role and the expertise that it brought to the Grenfell project should be firmly understood in that context and no other. Harley were not fire safety experts or experts in statutory compliance. Expertise in those fields would, as Harley reasonably believed, be the concern of others. Moreover, in the absence of a formal written contract, which of course there ought to have been, Harley's understanding of its obligations was inevitably shaped and informed by industry practices and the expectations upon cladding contractors as opposed to specialist facade consultants. Some of that industry practice is unsurprisingly reflected in the many documents appended to the letter of intent that was sent to Harley by Ryden. But Harley were not unrealistic as to that expected of them. As Ray Bailey himself observed, whether there was a contract or not, we had an obligation to comply with the building regulations. The numerous documents appended to the letter of intent included the NBS specification drawn up by Studio E. But in our submission, it is not correct to suggest, as it was by Mr. Millett, that by reason of the reference to it in the letter of intent, that Harley was required to consider the NBS specification any more than it can be said that Harley was required to consider the building regulations. Plainly, as a matter of universally understood industry practice, Harley was required to comply with the requirements of the NBS, including the materials that had been specified for in that document. The potential problem that arises then is an obvious one. How is any conflict between complying with the NBS and complying with the building regulations to be managed? Clause 2.12.1 of DOM 2, which was referred to in the letter of intent, required the subcontractor to notify the contractor of any divergence between the NBS and the statutory requirements. But what was not put to Mr. Bailey when he gave his evidence on this point is that that same clause places exactly the same obligation on the contractor, in this instance Ryden, to notify the subcontractor if he became aware of any such divergence. In this regard, what the documents show is not a linear chain of responsibilities, whereas some would have it. The buck stopped with Harley. We take issue with what has been said in the most recent written submissions of Ryden, that they delegated design responsibility to Harley. What the document I just referred to shows is that Ryden cannot be said to have delegated their shared responsibility for compliance to Harley alone. Instead, the reality, we argue, is much closer to that which Ray Bailey, based on his years of experience in the cladding industry, referred to as the raft of layers, with Harley, with the architect, with the fire consultants, with building control, to ensure that the products are, or the design is, compliant. It's not fair or accurate, we say, to suggest, as Exovia have in their recent written submissions, that nobody in the design team, including Harley, were concerned with compliance, or that they assumed simply that somebody else would take care of it. Harley had looked into fire classification of the Renault bond on the previous project at the Chalcott's estate, during which others, including specialist cladding consultants, Bickerdike Allen, Wintec and Sandberg, had also reviewed the fire classification and determined that it was suitable and compliant. Harley were further reassured of the suitability of that product by the investigation they themselves carried out in the wake of the fire at Taplow House. They engaged with discussions with representatives of Celotex, in which the suitability of RS 5000 for use above 18 metres was discovered. They sought the input of others in the design team, of the fire safety consultants, of building control, of manufacturers in relation to the design, layout and specification of cavity barriers. And they submitted drawings for approval by an architect who they believed had engaged in the expertise of fire safety consultants. So I pause there because I can see the time on my screen. I have about 5 or 6 minutes before I can finish, but I'm obviously entirely in your hands whether you'd rather I did that or you take a break now.
Well, I'm just going to check with the transcriber. I think if she's content to carry on, as she's indicating she is, it would be better to let you complete your statement now without a break.
Certainly. Then I'll do that with your leave. So our position is that Harley simply did not simply abdicate any responsibility for fire safety and compliance. They understood from their years of experience on similar projects that they were part of a wider team in which other parties would share in the discharge of that responsibility. Harley's role was to take what was specified by the architects, Studio E, and to use Ray Bailey's words, productionize the design for the facade set out by Studio E into something that could be fabricated and fitted to the external wall of the tower. Suggestions that persist, for example, in the written submissions of the TMO and the oral submissions of yesterday, that Harley pushed for the use of ACM, overlooked not only the evidence of Mark Harris, who when that suggestion was put to him maintained that instead Harley were advising on ACM as an option, but they also ignore the clear evidence we have seen and heard that long before Harley's involvement in the project, ACM was being considered, and indeed meetings were held between Studio E and Arconic about the use of Rhino Bond at Grenfell Tower. Harley submitted its drawings to the architects for their approval. It discussed the nature of the project with suppliers and the manufacturers of products that would be used at Grenfell, and it raised certain matters with building control, who were ultimately responsible for checking the compliance of the design and installation undertaken, and who on any view carried out numerous inspections of what was happening on site. Whatever the various subclauses of appendices or attachments to the letter of intent said, this was the reality of the role that Harley played on the ground, and that was a role wholly consistent, we submit, with that which would typically be expected of a cladding contractor on such a product. So may I just take a moment or two to conclude. This inquiry has been intensive, exhaustive, and far-reaching, and all the better for that. Every aspect of the refurbishment of the tower, more than I imagine any of the parties involved in that project would ever have contemplated, has been examined. And as I've said, there are going to be many lessons to be learned, not only by those within the construction industry, such as Harley, but within government, within the manufacturing industry, and beyond. The conclusions you reach, as you have said, must necessarily identify and focus on those factors which most directly led to the tragic loss of life on a scale that nobody before the fire could possibly have imagined. And in that respect, my submissions by way of summary are as follows. 1, Harley was not primarily responsible for the selection of the materials. 2, like every cladding contractor at work in this country back in 2014, they were misled about the fire safety properties of those materials. The BSR Group 1 speak in their most recent submissions of, and I quote, knowingly false and misleading statements in the BBA certificate for Rhino Bond. And they identify the detail of that which was not disclosed of the testing by the manufacturer. What those representing this CP do not explain is how Harley were to know this, and how particularly in light of Harley's experience of the fire on the Chalcott estate, my client could have known of the dangers of that product. 3, if the truth had been known, then of course, as the BSR Group 1 accept, it is, and again I quote, extremely unlikely that ACM PE would have been used. 4, fire safety was not Harley's area of responsibility. And in their criticisms of Harley, the BSR Group appear to ignore the obvious delineation and demarcation of areas of expertise. It was not Harley who were the architects charged with producing a compliant design, including the selection of safe products. Neither were they the fire engineers. Harley was entitled, as is described by those representing this CP, to rely on Studio E and Exovia to discharge this pivotal role. This is not, as I've said, an exercise in buck passing, because how on earth could a cladding contractor reasonably be expected or able to discharge these functions? And 5, against that background, and having regard to the hundreds of other similarly clad buildings that there are across this nation, we with respect say that the panel should reject Mr. Sakula's evidence that a reasonably competent cladding contractor would have concluded that ACMPE was unsafe on high-rise buildings. So those are our submissions on behalf of Harley, and I'm sorry to have encroached into the break.
No. Well, thank you very much indeed, Mr. Laidlaw. You haven't encroached significantly, and I think it was very helpful to hear the whole of your statement in one. So thank you very much. We'll rise at that point for the morning break, and we'll resume at 5 to 12, please. Thank you very much. Well, at this point, we're going to hear a closing statement on behalf of Arconic, made by Mr. Stephen Hockman, King's Counsel. Yes, Mr. Hockman.
Thank you very much, sir, and good morning to you and to your colleagues. It's nice to be here in person once again.
Yeah.
I would like to begin, if I may, by reiterating our profound sympathies for all those directly affected by the Grenfell Tower fire. And I would also like to reaffirm that we fully recognise the importance of the work of the inquiry itself in seeking to arrive at a true and fair analysis of the relevant issues. In turn, we are confident that we can rely on the inquiry to consider closely the submissions which we've made, both in writing and orally, including this present address. I have to say that perusal of the overarching written closings of some of the other core participants leaves us in some doubt as to whether they've given close consideration to our submissions. Some of them, at least, have clearly found it convenient to identify our clients as carrying the major burden, or indeed the sole burden of responsibility for the tragedy, thereby demonstrating not only that they have failed to find answers to the careful arguments which we put forward, but also demonstrating that placing blame on others, and especially on the company which we represent, is a very convenient way of avoiding their own responsibility. So great is the weight of criticism which has been directed against us that it sometimes seemed to our clients that there has been an agenda throughout to subject them to condemnation even before the case has been fully heard. We are, of course, entirely confident that the inquiry panel itself will not align itself with any such agenda and will give all our arguments fair and careful consideration. If, however, you wonder why I make the point, you've only to recollect the evidence which emerged in the course of Module 6 of the so-called political lie, in which within days, if not hours, of the occurrence of the fire, some in government were proposing that the use of combustible cladding was in itself a breach of the regulatory regime by reason of paragraph 12.7 of approved document B, even though the evidence in Module 6 demonstrated that paragraph 12.7 had no application to the cladding as opposed to the insulation. This is but one example of an attempt to create in advance an agenda for your work, a danger which I know that you and your colleagues will be alert to avoid. The same mindset was seen in an email from a government official on the 19th of June 2017, suggesting that the loss of one cladding company from the cladding market would not be severe. A clear example, you may think, of official prejudgment, if ever there was one. That's in CLG 000015376. Against that background, I hope I will be forgiven for starting my substantive submissions today by reminding you that at the material time, the manufacture and sale of ACMPE, whether by our clients in France or indeed by anyone in the United Kingdom, was entirely lawful. Moreover, we showed in our Module 6 closings that for many years the product was accepted in this jurisdiction and elsewhere as being suitable for use on an external facade on the basis that it was capable of achieving national class 0 or its equivalent. Without reiterating large sections of our Module 6 closings, we can perhaps remind you that in this jurisdiction alone, it was confirmed after the Grenfell fire that approaching 500 buildings had been clad in ACMPE, mainly, of course, supplied by others and not by our clients. You'll recall that in our Module 6 closing, we drew to your attention the transcript of the Lakanal House inquest in 2013, in which a striking passage of questioning took place during the evidence of Brian Martin. The questioner was Mr. Stephen Walsh, acting then as now on behalf of the London Fire Brigade. In response to propositions put by Mr. Walsh, Mr. Martin confirmed that generally the main surface of a building could be expected to be Class 0, that Class 0 was the most restrictive of all the classes, the most stringent short of non-combustible, and he accepted that Class 0 was designed to prevent fire on the exterior envelope of a building travelling from floor to floor in a way that makes it difficult to deal with from a fire authority's point of view. That was what was said in 2013. And we submit that the body of evidence which you heard in Module 6 requires the inquiry with respect to reject the proposition that such materials could not, in the years before the Grenfell Tower fire, have acceptably been used for external cladding. I'd like to build on that argument by making reference at this stage to the European system of classification. Of course, we know that for the purposes of the linear route to compliance, approved document B recognised as alternatives a product capable of achieving national class 0 and or a product capable of achieving European class or ENB. However, the evidence also shows that a product capable of achieving national class 0 need not necessarily be capable of achieving ENB. A good example is to be seen in the Alucobon BBA certificate, Alucobon being at the time a major supplier of ACMPE, which confirmed that their product achieved national class 0, but also END. The relativity reference to that is CEP 000064071. It follows that in the case of the many buildings clad in ACMPE, which had been supplied by Alucobond and supplied on the basis of the NC0 classification in their BBA certificate, there is no evidence that the product being used was capable of achieving a higher European classification than END. You may think that this evidence is important in putting into context what has been perhaps the most widely expressed criticism of AAP, namely that it allowed its product to be used at Grenfell Tower, even though, when fabricated as cassette, it may not have been capable of achieving ENB. In failing to achieve ENB when fabricated as cassette, the product was not in the least atypical. On the contrary, it was almost identical to the product manufactured and supplied by every other supplier at the material time. You will well recall that the product as supplied was in the form of a panel and was fabricated, whether as cassette or otherwise, by or on behalf of the purchaser. A purchaser would have been content to acquire the product on the basis that the surface of the panel could be regarded as having an NC0 classification, even if it was known that in certain circumstances it might not be classified as attaining ENB. I shall return to this point later. Having reminded you of our argument that at all material times up to the date of the fire, the manufacture and sale of ACMPE was legitimate, let me acknowledge that following the fire, controls on the architectural use of the product have now been tightened, at any rate in this jurisdiction. Herein lies, however, an important point which we have regularly stressed, namely that public policy has at all material times concentrated on controlling such products, not at the point of manufacture or sale, but at the point of use, and therefore the primary responsibility for any alleged misuse of the product must lie with those actually responsible for the design and construction of the architectural project in which the product is used. Again, I shall be reverting to this point later. As regards AAP, the above propositions do not, of course, cover comprehensively the circumstances of the sale, and in this case, the nub of the criticisms against AAP lies in the alleged failure to give a suitable warning as to the use of the product in particular circumstances, or alternatively the making of specific misrepresentations. We have throughout submitted, ironically in view of everything that has been said against us, that it is the BBA certificate itself which embodies our defence against the allegations of failure to warn and/or of the making of misleading statements. This is, of course, because the BBA certificate, read as a whole, as it must be, not only makes it crystal clear that the product was combustible, but also contains explicit limitations or disclaimers as to the extent to which a purchaser can use the product in a particular architectural context without himself taking responsibility for testing and checking that it is suitable. Again, as we have repeatedly pointed out, this reflects the express provision in the domestic regulatory regime requiring a purchaser to carry out such tests and to make such checks because of the variability of performance that can arise depending on the circumstances of use. And as you will recall, approved document B at Appendix A includes in its introduction the following: any test evidence used to substantiate the fire resistance rating of a construction should be carefully checked to ensure that it demonstrates compliance that is adequate and applicable to the intended use. Small differences in detail, and mark this please, small differences in detail such as fixing method, joints, dimensions and the introduction of insulation materials may significantly affect the rating. And then Appendix A at paragraph 16 makes a similar point specifically in relation to tests relating to the surface spread of flame. Results of tests, it says, on proprietary materials are frequently given in literature available from manufacturers and trade associations. Any reference used to substantiate the surface spread of flame rating of a material or product should be carefully checked to ensure that it's suitable, adequate and applicable to the construction to be used. And then this again, small differences in detail such as thickness, substrate, colour, form, fixings, adhesive, etc., may significantly affect the rating. This acknowledged variability in performance has important implications for the correct interpretation of the BBA certificate. No one proposing to use a combustible product could have interpreted the certificate as claiming not only that a panel was capable of achieving ENB, but that it would achieve ENB in any and every context. It is precisely for this reason that the certificate stipulated for further testing in order to establish the particular level of fire resistance to be anticipated. Putting the same point in a different way, if those concerned in the refurbishment project decided to assume that ACMPE panels were suitable, regardless of the various factors mentioned and listed in Appendix A, in other words, regardless of such matters as the fixing method, the type of insulation, and so on, that is an approach for which they must be held responsible. It is not an approach which was authorised or even acquiesced in by AAP or, for that matter, by the BBA. Other core participants, noting the 2013 email from Deborah French in which she suggested that AAP could control the choice of core, have relied on this as a convenient method of distancing themselves from the selection of ACMPE as opposed, for example, to the fire-resistant alternative for use at Grenfell Tower. There is, however, patently no substance in this line of argument. None of those involved in the refurbishment project can realistically say that they relied on the advice of Deborah French, who herself concedes that that email overstated the extent of the advice which she could and did provide. Of course, and again this is a matter to which I shall return, if a specific query had been raised and answered by the relevant AAP team, then the situation would have been different. As a supplementary comment in relation to the regulatory regime, I think it's worth pointing out that contrary to the oft-repeated argument against us that we were seeking to take advantage of a weak regulatory regime, such characterization of the then applicable domestic regime is at any rate much oversimplified, since the provisions of ADB paragraph 12.5 contain a very specific warning as to the risks involved in the use of combustible products. As a further supplementary point, this may be a good place to address the evidence on which others have relied to inculpate AAP in terms of attributing to the company what is said to have been its knowledge of the risks involved in the use of the product. I'm referring here mainly to the evidence of other fires taking place either in this country or overseas, and there are a number of general points which are worth reiterating in this context. Firstly, it is quite clear that although some of these fires did receive publicity at the time, that observation falls a long way short of accepting that there was any known, detailed, let alone scientific analysis of the actual causes of such fires, still less of the part played by particular construction products, the present inquiry having surely demonstrated how complex and time-consuming such an analysis would have been in any event. Secondly, and even assuming that any one or more of those fires, such as the fire in Oslo in 2006, might have been a signal as to the risks in using any particular product, it does not follow that the manufacturer of that product ought to draw the conclusion that the product should be withdrawn from the market. On the contrary, and given that public policy universally imposed relevant controls at the point of use, a manufacturer would be entitled to expect the regulatory regime to achieve that objective and to conclude until it was shown otherwise that the occurrence of a specific fire in a specific jurisdiction was due not to the weakness of the regime, but to the fact that for a particular reason, the regime was not complied with in the case of the fire in question. So it is with the manufacture and sale of any product which is capable of being used in a dangerous manner. Against the information about other fires which might have pointed to risk must be set the evidence of fires which demonstrated that the ACMP product in itself did not necessarily prejudice safety. We remind the inquiry of the Taplow and Sudbury examples, Sudbury in particular being a building which was clad in PE fabricated as cassette, in which the spread of fire did not prejudice human health. And we stress that in our Module 6 closing, we dealt in detail with the evidence relating to those two fires, and we explained why Professor Bisbee was wrong to suggest that either fire could be described as a near miss. In essence, that allegation we submitted is disproved by the contemporaneous documentation. We did incidentally submit questions for Professor Bisbee on these topics, but those questions were not pursued. We also remind you of the other examples given by Professor Torero in Phase 1 of fires where the spread of the fire up the building did not lead to fatal consequences. I now want to refer in greater detail to the issues surrounding the BBA certificate and the circumstances of the sale for Grenfell Tower. Let me emphasise at the outset that in truth, those involved in selecting and acquiring the product from AAP approached the acquisition in entirely the wrong way. Firstly, and again this is a point to which I shall return, in view of the scale and complexity of the proposed refurbishment, it must surely be clear that on any view it was essential for the choice and configuration of the components of the refurbishment to be the subject of a holistic assessment by a fire or facade engineer. However, even if no such individual were to be instructed, it was surely manifestly incumbent on all those concerned, including Studio E, Exover, Ryden and Harley to check carefully the suitability of the materials to be used and the appropriateness of the proposed configuration. To check carefully those matters. This is perhaps particularly true, and with all respect to what we heard before the break from Mr. Laidlaw, particularly true in the case of Harley, who, as we pointed out in our Module 6 closing, was at least a specialist cladding contractor and an experienced industry player whose employees had attended CWCT meetings where topics such as filler and routes to compliance had been discussed, not matters which Harley have addressed in their closings. As I have already mentioned, ADB Appendix A itself requires that any test evidence underpinning a decision as to fire resistance of a product should be carefully checked to ensure that it's applicable to the intended use. As you know, our clients had a technical sales support team in France which could answer queries from purchasers and others, and sales staff, including Ms. French, were able to refer queries to that team. This is a procedure which notably was never followed in the case of Grenfell Tower, even though the choice of other products, such as the combustible insulation and the proposed configuration of, say, the architectural crown, clearly demanded the utmost thoroughness in assessing the choice of products. There is, we submit, an inference that both Ryden and Harley, anxious as they were to achieve what is euphemistically described as value engineering, deliberately failed to ask any question which might have led to the choice of a different product or fabrication or system. And given that as from 2011, the ENE classification for ACMPE in cassette fabrication started, as we explained in our written closing, started to be widely circulated, it is inevitable that on inquiry of the team in France, any of those involved in the Grenfell refurbishment would have received this information. So the issue is not what any of those involved in the refurbishment already knew, but why they didn't take the trouble to carry out the checks which ADB requires and which the very complex nature of the design would also mandate. Not only that, but as I've already stressed, a careful reading of the BBA certificate itself would have put everyone on notice of potential problems and would almost certainly, and I put it as high as this, have saved the lives of those who died in the fire. In Section 6 of the certificate, it provided explicit help to any purchaser or user as to the steps which they ought to take to satisfy themselves that the system was appropriate, particularly as regards the attainment of sufficient fire resistance. And again, it's a point that I shall come back to. In these circumstances, it is profoundly disappointing that numerous core participants persist in the unjust allegation that the BBA certificate was misleading, an allegation which we have repeatedly challenged and in relation to which we have set out a cogent case to the contrary. The key point which we have made, and we submit is absolutely indisputable, is that the certificate related to the product manufactured and sold by AAP, namely an ACM panel. Although the certificate illustrated methods of fabrication and fixing and dealt with aspects such as wind loading, it made no representation as to the level of fire resistance which would necessarily be achieved once a panel had been fabricated, whether for fixing by rivet or as a cassette. Moreover, the inquiry has numerous examples of other BBA certificates which are in a similar form to ours and which also made no distinction between the level of resistance to fire which might be achieved by different methods of fabrication, nor did any of the certificates claim that a panel would achieve a particular European class result in any and every system and in any and every configuration. You will remember the evidence of Mr. Gregorian of the BBA, who was at pains to stress the limited purpose of the certificate as a product certificate, despite repeated questioning to the contrary. It's particularly sad that continued reference is so regularly made to what is said to be an admission by the president of AAPSAS, Mr. Claude Schmidt, as to the allegedly misleading nature of the certificate. If you accept our primary argument, which I've just summarised, which is that the certificate was not misleading, then the very fact that others have been left with the impression that Mr. Schmidt admitted that it was tells you that his evidence needs to be considered with very considerable caution. Regrettably, the relevant part of the questioning on day 91 from page 4 onwards, and incidentally at a time prior to Mr. Gregorian giving evidence, the relevant part of the questioning proceeded on the basis that the certificate related to the product in fabricated form. Mr. Schmidt, plainly struggling to answer in French a question posed in English on what we submit was an erroneous basis, attempted at page 5, line 7, to challenge the question by observing that it was said that one wasn't going to be referring to cassette or rivet. He also made the indubitably correct point that he was not himself involved in the drawing up of the BBA certificate, which was, of course, ultimately the responsibility of the BBA. It must also be remembered that it was necessary for us, in the course of Mr. Schmidt's evidence, to point out in correspondence that there was a discrepancy between the French language version of the word misleading and the word in its normal English usage, following which, as a result, the English version of a number of questions was revised. At this point, the nub of Mr. Schmidt's response on day 94, page 65, was that the certificate might be misleading, especially if you take the reference to ENB in isolation as applying to any and every fabrication of the product without reading the certificate as a whole. At this point, he was, to the best of his ability, identifying precisely the, with respect, erroneous approach adopted in the earlier sequence of questions. In our respectful submission, therefore, no weight can be attached to any apparent admission as to the BBA certificate being misleading, since the propositions put to Mr. Schmidt erroneously proceeded on the basis that the certificate related to the product in fabricated form. In our written submissions, we have also dealt in considerable detail with the position of Mr. Claude Verler. We remind you that the inquiry has already acknowledged in correspondence that counsel to the inquiry will make no reference in his closing to the reasons why any particular witness has not given oral evidence. For present purposes, I must be selective in reminding you of a number of key points. The first is the allegation that Mr. Verler manipulated the testing process by increasing the size of the gap between the panel and the substructure. This allegation has plainly, we suggest, not been substantiated. We now know from recently disclosed material emanating from the CSTB, the testing body, that matters such as this were closely monitored by them. Moreover, you will recall that Dr. Lane pointed out in the course of her presentation on day 68 in introducing Module 2 that the 1994 Connolly report showed that a reduction in the so-called gap, in other words, the width of the cavity, will reduce the surface spread of flame over cladding material. As we observed in our Module 2 closing, this would appear inconsistent with the allegation that for the purpose of CSTB testing, the width of the cavity was increased artificially in order to improve the outcome. Secondly, I remind you that Mr. Wöhler did have some grounds for anticipating that a panel of the product could achieve National Class 0, not least because a similar, albeit not identical, product known as RB33 had achieved Class 0, even though the combustible core was wider and the aluminium skin narrower than in the case of RB55. And again, we submitted a question on that point for Professor Bisbee, which was not in fact put to him by counsel. We submit, therefore, that the inquiry would not be justified in drawing any adverse inference as to the good faith of Mr. Wöhler at the material time. Insofar as there is later email correspondence sent by Mr. Wöhler, seemingly accepting that he believed that there was a problem in relation to the use of ACMPE, and indeed in the testing process, it is our submission that if that was the view of Mr. Wöhler at the material time, it represented an overcautious view of the position, since the continued manufacture and sale of the product was in itself legitimate and did not necessarily prejudice health and safety. Above all, we submit that Mr. Wöhler's reliance on the ENB result for the product when fabricated as rivet has received strong support from the outcome of the experiments by Professors Bisbee and Torero, particularly in relation to what Professor Bisbee called fixing case C. As Bisbee acknowledged in his report dated the 15th of December 2021 at paragraph 583, fixing case C resulted in the cladding arrangements tested simply never growing to full involvement of the ACM. He accepted that this can be attributed to the fact that the rivets mechanically hold the aluminium skins together and prevent the skins opening up. This in turn reduces the exposed surface area of PE that can burn and also discourages mobilization of molten PE into the drip tray. This reduces or slows the supply of fuel to the pool fire burning at the base of the ACM and prevents escalation into the cladding system. The importance of this evidence is that it shows that the results of these experiments was consistent with the relatively favourable result obtained by a Ronabond PE panel on testing in both 2005 and 2011, where rivet fixings were used. At the very least, the evidence shows that a Ronabond PE panel was, as we have submitted throughout, capable of achieving an ENB result, and that those concerned at the time could genuinely have formed this view. Those conclusions are, we submit, not affected by Professor Bisbee's speculative comments as to what might have followed if his actual experiment on fixing case C had continued well into the future, a point on which, as we have explained fully in our written closing, his own evidence underwent a number of variations. I mentioned previously that a purchaser of the product would have been content to proceed on the basis of an NC0 certificate, even if the product was known in certain circumstances not necessarily to achieve European Class B. If this is right, it would follow that the fundamental line of attack against AAP, said to arise from the non-disclosure of the cassette testing in 2005, can be seen as a non-issue. In the circumstances that prevailed thereafter and up to the date of the Grenfell fire itself, a product which could be regarded as achieving National Class 0 was widely seen as being fit to use, and AAP was by no means alone in selling product, even if in certain circumstances, the EN classification, the European classification, relating to the specific fabrication or system adopted might be lower than Class B. And I would add that even if the BBA had been made aware that in certain circumstances the product would not necessarily have an ENB classification, they had evidence that the product was capable of achieving that classification. And given that approved document B, Appendix A, expressly acknowledges that variations are entirely foreseeable, the BBA ought still to have been prepared to conclude that the product could be regarded as having a Class 0 surface as mentioned in the BBA certificate, especially as the certificate was to go on and advise further testing of the level of fire resistance of the full cladding system. Now I need, if I may, to go on to discuss to some degree the actual causes of the tragedy at Grenfell Tower. The first key general point to bring out here will be what perhaps can be described as design failures. I refer here to our oft-repeated argument that the essential problem, critical from a causative point of view, was the failure of all concerned, including Studio E, Exova, Ryden and Harley, to actually comply with the advice in the BBA certificate and to arrange for expert fire assessment of the design and configuration, the system, of the newly designed facade of the tower. It can be said with confidence that had such a comprehensive fire assessment been carried out, the combustible nature of the chosen insulation products, incompatible as they were with ADB paragraph 12.7, would at least have signalled the need for a complete rethinking of the choice of products and their configuration, and the tragedy would then have been avoided. I now go on to deal, as I did in the written closing, with the rather extraordinary position taken by the insulation manufacturers, in particular Celotax and Kingspan, who will have been all too well aware of the market pressures to utilise less voluminous but therefore combustible products. These companies claim to derive support for their position from the Bisbee-Torero experiments, in which similar results were obtained in the use of non-combustible as well as combustible insulation. In the first place, it cannot be assumed that the outcome of an actual fire, such as that which occurred at Grenfell, as distinct from in experiments, that the outcome of an actual fire would have been the same if non-combustible insulation had been deployed. That, as we pointed out in our written closing, is pure speculation, and indeed, as I shall explain in a moment, there is evidence that the outcome would not have been the same. But secondly, and equally importantly, the conduct of Celotex and Kingspan in assuring the market that their products could be used at height was surely a key factor in the failure to which I have referred to carry out the comprehensive fire assessment, which was the critical causative failure in the case of the Grenfell fire. Next, I want to cover briefly the evidence as to the start and spread of the Grenfell fire, which we covered in much greater detail in our written closing. 5 points, I submit, stand out. One is that in contrast to so many other fires involving combustible cladding, at Grenfell the spread of the fire and of the resulting smoke was not only external but also internal and throughout the building, a process which resulted from the defective internal compartmentation, from which, of course, AAP was not responsible. The compartmentation failures were acknowledged by the inquiry itself in Phase 1, but in fairness to AAP, it's vital that this point be fully acknowledged also in Phase 2, not least because, as Mr. Walsh pointed out yesterday, the compartmentation failures were a key factor in the entire building failure which undermined the stay-put strategy. Secondly, it's worth emphasising the Module 7 evidence as to the contribution to the fire of the apartment contents, which in the end were probably more significant in quantitative terms, in terms of heat loading, than any other factor. Thirdly, as regards external spread, the way in which much of the ACMPE was fabricated and configured, the Crown being an example, was so unorthodox as to rebut any allegation of responsibility on the part of the manufacturer in any event. Fourthly, as regards the contribution of the ACMPE in quantitative terms, it must be remembered that a significant number of the panels fell away in the course of the fire without having reached full combustion, the inquiry having confirmed to us in correspondence that no specific information exists as to the number of panels which fell away. Fifthly, we restate the importance of the role of the combustible insulation, and that is the topic to which I now turn. As we pointed out in our written closing, a number of important further points can be made as regards the role of the insulation in the spread of the fire. Firstly, we know from the Phase 1 evidence that in general terms, the insulation having a low thermal inertia would have ignited quickly in response to the fire as it emerged from the window surrounds. Secondly, we know from Bisbee's report, again the one dated the 15th of September 2021, that the ignition and spread of the fire through the ACM panels was significantly affected both by the type of insulation and by the absence of foil facers. Thus, in his section 9, entitled Conclusions, Bisbee states the following 3 points. Firstly, the ability of the insulation to retain energy within the cladding system and to promote more rapid and extensive heating of the ACM is the decisive factor for foil-faced insulation products rather than its combustibility per se. But 2, in the absence of foil facers, or in the case of the Kingspan insulation, the foil facing being perforated, the contribution of energy through the burning of the combustible insulation products may be significant to the ignition, spread and fire growth in the cladding system. And 3, the contribution from the combustible insulation without foil facers to the total heat release rate may indeed be comparable to that from the ACMPE. This being because the rapid heating and ignition of the low thermal inertia insulation in the absence of protection from a foil facer results in widespread flaming over the surface of the insulation with consequent additional heat release. And those points you will find in the Bisbee report at paragraphs 686 to 689. In his oral evidence on day 291 at page 40, Professor Bisbee himself accepted that if non-combustible insulation had been used, fire spread through the window surrounds would potentially have been delayed, albeit not substantially. You'll recall my oft-repeated comment that a 5-minute delay would have been enough to enable the fire service to extinguish the fire whilst it was still contained within flat 16. I stress that these points are not made simply to attack the manufacturers of the insulation, but because they are highly relevant to the contribution of the insulation to the start and spread of the fire, an issue which the inquiry itself, in its Phase 1 report, indicated that it wished to examine further in Phase 2. And I add, therefore, that in our respectful submission, not only was Ms. Barwise wrong in her categorisation of the role of AAP, but she was also wrong in her approach to the responsibility of the manufacturers of the insulation, as her colleague Mr. Williamson himself observed yesterday. The final substantive topic with which I must deal concerns the production of toxic gases, which were ultimately of critical significance in the case of many of the fatalities. Broadly speaking, one can say that a number of key issues arise in this connection. The first issue is as to the stage at which toxic gases were produced, an issue which may affect the extent to which such gases may have been causative of the fatalities. The second issue is as to the relative quantities of the individual gases concerned, which may throw light on their individual significance. And the third issue is as to the chemical nature of the relevant gases, which may throw some light on the actual impact of those individual gases. In summary, it seems clear that both the combustion of the ACMPE and the combustion of the insulation would have given rise to the production of toxic gases in the form of carbon monoxide, which can in sufficient quantity be fatal in their effects on human beings. Even more dangerous to human life, however, was the hydrogen cyanide, which it is clear was produced only by the insulation and not by the ACMPE. Turning to the stage at which the gases were produced, it seems likely that this occurred mainly following the re-entry of the fire, perhaps preceded by toxic smoke, into the various apartments. However, there is, as we see it, no clear or comprehensive evidence as to the period of time between the entry of the smoke or fire into a particular flat and the moment of the occurrence of fatalities within that flat. It can perhaps be said that it is likely that the process of combustion continued for some time, maybe for some considerable time, after those inside any particular flat had sadly passed away. And that is not only because of the continuing effects of the combustion of the cladding products, but also because of the very considerable additional effect of the combustion of the apartment contents. Indeed, it seems that at least half of the heat loading occurred as a result of the combustion of the apartment contents rather than the combustion of the components of the cladding system. In our overarching written closing at paragraph 25, and by way of further clarification of that paragraph, we mentioned the evidence of Professor Bisbee on day 290, and one can see from various passages on pages 19 to 23 in the transcript for that day, that estimating the contribution of the apartment contents at not less than 50% and that of the insulation at up to 10%, the amount attributable to the ACMPE could well have been around 40%, as we suggested in paragraph 25 of our written closing. Comparing the production of gases from the insulation and the ACMPE respectively, the evidence of Professor Purser seems to be that the two cladding products were roughly equally responsible for the toxic gases. We note the recent correspondence on behalf of Celotex attempting to urge a modification of this conclusion in their favour, and the response of Professor Purser concluding that the arguments put forward in that correspondence do not affect his broad conclusions. As between these approaches, we support the Purser response. We have, however, highlighted a number of reasons why the inquiry should hesitate before reaching any firm conclusions on the basis of Professor Purser's evidence. Firstly, he acknowledges that the influence of the ACMPE would be diminished if the combustion of the PE took place in circumstances which were better ventilated. On the face of it, and since the PE was on the external side of the cladding system, it would seem that this should be treated as better ventilated, and Professor Purser did not adequately explain why his original finding in that respect was subsequently revised. Secondly, as I've already mentioned, Professor Purser took no account of the fact that a good number of the ACMPE panels fell away without achieving full combustion. And thirdly, Professor Purser's conclusions depended on drawing inferences from the so-called BRE reconstruction, which was an unsound evidential platform, given that the BRE reconstruction was in any event very different from the actual fire at Grenfell, and given also that there was a breakdown in data collection during the reconstruction period prior to the final few minutes. In any event, neither Celotex nor Professor Purser take account of the so-called Effectis study. The reference is INQ 3014908, involving experimental tests performed on 9 different compositions of ACM panels with several insulants. This study showed that ACM-PE has the lowest carbon monoxide production of the various ACM products, and that the carbon monoxide as well as the cyanide production is primarily driven by the K15 insulation, closely followed by PIR. In particular, one can see from figure 17 in the Effectis paper that the emission rate of carbon monoxide was much higher in the case of ACM-PE coupled with the insulation compared with the rate observed in other experiments. And one can see from figure 18 that the carbon monoxide concentration produced by a combination of ACM-PE coupled with K15 or the PIR is several times higher than in the case of ACM-PE coupled with non-combustible insulation. 2 further brief points on this toxicity issue. Firstly, the toxicity of the combustible insulation was surely far greater than would have been the case if the insulation had been non-combustible, as it was in some of the Effectis experiments. And secondly, it is reasonable to infer that the insulation manufacturers, primarily Celotex and Kingspan, must have been aware of the toxicity of their products, as explained in detail in the written closing of BSR Team 2 at paragraphs 161 and following. So I move towards my concluding remarks. I have concentrated in what I have said today on the role of the PE and of the insulation, but of course it's right to remind you briefly of other important causative factors, including the failure to remedy critical fire precautions or compartmentation defects. I've already mentioned and stressed the point about compartmentation, but defects such as door closers, the criticisms made, if you accept them, of the smoke control system and the failure to upgrade or refurbish the lifts. So we respectfully suggest that in our various submissions, both written and oral, including this one, we have persuasively answered the numerous criticisms launched in our direction, and we ask you all, please, to view those submissions with favour. And above all, we invite you to judge the conduct of AAP personnel by reference to what was known or understood at the time, and to discount the wisdom of hindsight. Thank you very much.
Well, thank you very much, Mr. Hockman. Well, it's a little earlier than usual to break for lunch, but I think it's convenient to do that now because the next statement is going to be made by Mr. Geraint, Webb King's Counsel, on behalf of Kingspan, and he's going to take more than 10 minutes. So we'll rise now and we'll resume, please, at 2 o'clock. Thank you very much.